The forum is now open for discussion. Is there anyone who'd like to start? If you just put up your hand, I can get an order of commentary or questions. There's a lot of questions there from David, so I don't expect everyone will have them first. Kim?
Well, I suppose the first thing, just have a question. You started saying, David, that there was one of your headings was what would good fieldwork questions be, I think, and then I was waiting for the answer, but I didn't hear it. If you gave it, I don't know, did you? Have you got a list or something that you employ, or?
Well, I've got certain fees that come into operation when I that question. No. No, my answer is I don't have a proper answer at the moment. And partly I think the problem is that, as I say, the answer might vary with what kinds of brief the research is given. I guess I'll just say one thing, which is in one case I have done work on where I've tried to sort of ask questions like, well, can people do anything with country these days? And I suppose the responses I've had have led to some of my questions, because it's led immediately to complications about whether people are going to talk about young people now making money out of country from various business options, whether we're talking about making money from, if you like, natural resources in the country, or whether we're talking about native title holders running businesses, say, with cattle and mining and tourism and things which connect to the Australian economy. I suppose the comment I'd make is that I don't think some of the lawyers I've had discussions with fully appreciate the difficulties or the complications of that kind when anthropologists are going to try to operationalize the relevant questions.
Nick?
This is a start to have the conversation about what they might look like.
Could I just ask you a question, David? If the situation is that people only have to demonstrate there is a right to use resources for any purpose, and it's not necessary for them to demonstrate that people have actually exercised that right, then the question that comes to mind is, how big can the gap be between the time that you can, say, make a reasonable demonstration the right existed, say, from the archaeology, to the fact that you're living in Melbourne or in somewhere in Victoria, and there's no evidence that anybody in the last 4, 5, 6, 10 generations has exercised that right. So how wide's that gap? Because I can think of the axes at Mount William, right? You could mount a good argument. This wasn't just gift exchange, that people were producing lots of them. There was standardization, there was specialization, they were scarce, their value went up as they got further away. All of this is, there's stuff on this. And yet I don't guess anybody in Victoria has done that for the last 200 years.
Well, indeed. I guess it's parallel to research about connection, where the same issue about historical adaptation and change arises. I don't know. It may be that the anthropologists would need to address those issues available in the classical literature about what the right was, seemingly evident from what actually happened, and posit queries about what that right might have been transformed into now. I mean, I'm not answering this terribly well, but it's part of the general issue about how in native title do anthropologists deal with the question of change and adaptation. I think it's the same thing as in connection reportage.
Mike, I know when you responded to the invitation to this, that you'd said you'd already been involved in some research for perhaps a compensation, was it? And I wondered if you wanted to weigh in here on what your experience had been.
Thanks, Julie. I was asked to investigate any purpose rights. And that was one of it was the first claim of that nature in the CLC region. And I guess one of the learnings I took away from that was the importance of having or providing some feedback in terms of being involved in the writing of the brief. I know David referred to the brief in this regard just earlier, but I found that the brief, it was very difficult to, the brief was I found quite repetitive and quite complex and in some ways confusing. And I think that if I'd had some input into that at an early stage of writing, that it would have made the research much more straightforward. And I also wanted to comment on David's reference to different ways of approaching fieldwork and eliciting information. And I found in regard to that research, that hypothetical questions were not a very useful approach. That it was quite fraught with opening things up to confusion and that I suppose it depends, I think, to a large extent, I found on the informants, I guess their approach or perhaps my ability to put such questions in a way that was easily understood, and I found that in some cases that wasn't very successful. I found that perhaps a process of elimination of what rights, what people could exploit materials and resources for was one way that was, I suppose, quite successful, and also where you could use examples of things which were already people were using or exploiting resources for, as opposed to hypotheticals, was a more useful approach.
Thanks, Mike. Ophelia's got a question which goes to something that I think is a general concern about the terms of reference from lawyers in briefs. Ophelia?
Hi, I'm just going a little bit on what Michael was talking about and David. I always get very uncomfortable and cranky when I get a brief that talks about asking me to do anything to do with rights, because I don't see that as my role. I look at what people do with the country and on the country, their connection to country, and the lawyers can decide about whether that is a right, under the Native Title Act. So I just wonder if we perhaps need to take a step back when we're talking about some of this, and rather trying to go into the field with a list of rights that we need to look at, look at what people actually are doing on the country and have done in the country in the past. I don't mean to sound naive and say, oh, you know, that's, you know, to try and, what I'm saying is to actually push back a bit more and take the wider view, because if we get stuck on just this right and this right and this right, we just get back to that same trouble about, you know, breaking up the bundle, as Nick talked about.
Thank you. Pam?
Thanks very much. And this might follow on a bit from Ophelia. Thanks, Nick and David. They were both really fantastically useful. I just wonder whether this idea of the any purpose use right and the differences that you might find within a group about what people say country can and can't be used for, it raises for me two issues. One being about the interaction between different types of rights and whether or not there's a kind of hierarchy of right within this kind of the overall concepts that we're dealing with, and whether or not there's any way, so there's this sort of a hierarchy of rights, or whether any rights are qualified and whether they're the rights holders in fact. So it's partly to do with the distribution of the rights and the relationships of the rights to each other. And I wonder if that's perhaps overthinking it, or whether or not there's something in there that either of you might want to respond to as being perhaps of use when trying to understand, particularly in the contemporary setting, how there might be differentials between differently positioned people within the society we're looking at.
Thank you. Nick, you're on mute if you're about to respond.
Right. Well, let me just say something from the literature, the older literature. I think what's clear from that is that there were people who gave permission, presumably, it's not always clearly defined, but people go and see some senior person, particularly in that Selwyn Range, Flinders Range area, because generally it was the people who'd come from a long way who did the work, who went and actually harvested the pitchery or dug up the ochre and things, and it wasn't the local TOs who did it and then sort of said, you know, give me a boomerang and I'll give you some ochre or give you some pitchery. It's the people who came, asked for permission to harvest the pitchery and then did it themselves and gave gifts to the locals. So that suggests there was a sort of hierarchy of authorization. But I don't have anything else to say at this stage.
Just add one point that might connect with both Ophelia and Pam a little, and also Kim's point about, okay, well, what do we know from actually trying to do this work? One thing I know is that if you ask the question, is there anything people can't do with country? Or is there anything some people can't do and other people can? Or who can say whether the native title holders, if you like, or the people whose country this is can do anything they like with the country? Of course, we get immediately enmeshed in all kinds of cultural rules about certain places where things shouldn't be done, other places where they can be done, certain categories of person who can't go and do things in certain locations, whether that be via age or gender or some other kind of seniority, or in settings moving towards these very kind of long settlement history settings. I want to try and, I think it's so important for us to keep that in mind, rather than, in fact, the cases where we've got something happening so far are all about Torres Strait or Borroloola or Timber Creek or Spinifex country, you know, but what about East Coast Queensland, Central Queensland, or such a place where posing that question may have the answers may be about, well, really the right people who can say whether anything can be done are such and such, and that may be a product as much of contemporary organisational politics as it is any kind of accurate portrayal of what the legal process wants to understand as law and custom. Now, I've sort of had some conversations with some lawyers about this, and I'm not sure yet I understand. I think I've had a couple of responses where people have said, now look, anthropologists shouldn't address all this question of rules for certain categories of person, or different locations where there will be restrictions, but not in other cases. They want the research to somehow cut through to the bottom line of whether this overall generic right exists, which makes sense if you're speaking from a legal perspective. But I suppose at the moment, my own thinking is I'm unclear as to how an anthropologist can do that. And it does connect to what Ophelia said. It's much easier, I think, for a researcher to go in and talk to people about, you know, rights in country generally, and connections to country, and the spiritual significance of country, and all of those things which people do in connection research, and I should say are beginning to do in compensation research as well. But starting to talk about discrete rights one by one by one by one just really takes us to what the lawyers want to hear rather than what the people on the ground want to say.
Thanks, David. And David Martin would like to chip in.
Good. It's a comment really, both of what David said, or in reference to what David said, and also Ophelia. In reference to what David said and thinking about unrestricted rights or so forth, there's a question of scale. I think that sort of jibe almost I made in something I published some years ago. Does native title just entitle you to be native? Where does the limit stop? Small scale activities on country that weren't directly done in the classical past, one thing, but what if people are proposing to open up or have as a joint venture with a large scale mine like the Century Mine that ends up in a gigantic pit on country, etc., etc. So unrestricted, it makes me wonder what we're meaning by unrestricted and how expansive is the transition from what was to what is. The other thing, though, is I want to comment on in relation to Ophelia's point, with which I profoundly agree, that is the one about rights and how she feels uneasy. I do, and as a matter of course, I refuse to give answers in relation to rights, but it's for this reason. It goes to the question of what's native title. It's in a transition space and in a translation space and a recognition space between a given system of what the law calls law and custom on the one side and Australian law, especially Australian property law on the other. It's a translation from whatever the terms of that system were into rights and interests. Why are they defined in that way? Because that is the fundamental way in which Australian, and more than Australian, but Australian property law understands ownership. It is a bundle of rights and the interests that derive from those rights. And a given system may or may not have had what is a direct correspondence to rights and interests in that system of law. It's Robert Blowers, had a very interesting article where he said that establishing the rights and interests is not the job of the anthropologist, the expert, as he said. It is the job for us. I agree with that. I think we should be doing what Ophelia is saying, which is setting out, and which in a number of contributions, that setting out how that system worked, what were its basic terms. And we can talk about them in terms that relate to using resources, for what purposes, and so on and so forth. But once we get into the language of rights and interests, we're directly engaged in the language of law and in legal constructs. And I think that's a dangerous place to be.
Okay, I don't know whether Tony wants to comment on that, but go ahead.
Okay, yeah, thanks, Julie. Yeah, just to follow up on that conversation, you know, with the studies of property theory in general, we know that nowhere in the world are there land tenure systems where people actually own land in an unencumbered way. So what they do own is rights and interests in land, and that's always in relation to other people. So I think, though I'm sympathetic to the approach that wants to avoid the splitting up of a holistic set of rights and interests in land into the bundle of rights. What we can do in the field is to ask about that relational exercise of activities in relation to different types of groups and individuals that the person who owns rights and interests in land encounters. So, you know, I think we can address it to some degree by, without avoiding the whole question of rights and interests, by asking our interlocutors in the field about what sorts of things you can do in relation to those groups and those persons and that particular category of relatives. And so I do think that enables us to address, you know, fundamental aspects of how property is always, ownership of property is always mediated through the other people in that social world and those who are outsiders to that social world.
Is there any? Yes, Mike.
Yeah, so thanks everyone for those very useful and interesting contributions so far. I was just wanted to just raise a question in regard to previous comments about whether it's the anthropologist's role to identify rights and interests, and following on from Anthony's comment just before that, I think while maybe perhaps it's not the anthropologist's role to specifically address rights and interests, it is our role to identify the, you know, or obtain the information which an advocate can then use to run an argument about rights and interests. So I just wonder whether, although maybe specifically rights and interests aren't, you know, the purview of the expert, that nonetheless the data that you're seeking to obtain does bear directly on that question.
Okay, there's a general question. Responses?
Okay, Julie, I'll make a point. It seems to me if one of the, and it goes back to the question I asked David Trigger at the beginning, because the question isn't exactly the same about continuity between the pre-colonial and the present, because basically most of the sort of obvious trading activities of in many areas finished, you know, very quickly after contact. So there's been, you know, 150 or 200 years of not doing anything. But archaeology does provide very strong evidence for economic behavior which is consistent with the right to use resources for any purpose, because you can see from the archaeology that people have produced more of something than they need for their own uses, that they produce this surplus from materials that they own or control or from their own area. They've used it in a number of different purposes to transact for other things. The ethnography says what they're seeking in return. You can show scarcity value of things as they move away from their source of origin. You can show specialization. You can show people were making things to particular formats, the axes or spearheads, and that you can show that there was a response to demand, that the supply rose where there was demand. That this all can come from the archaeological literature very easily, and some of it comes from the ethnographic literature. You can show, certainly from the ethnographic literature, that there was a high value placed on fairness and equivalence in exchange, i.e. that they weren't seeking profit, but there were ideas of fairness and equivalence. The archaeological record provides evidence about economic behavior without the issue of rights. And it is very strong. And that's why I think, say, the Mount William quarry thing in the southeast is very strong evidence. You could build it round there for the people having the right to do something with the resources beyond service their own needs and the needs of people in the immediate area.
Can I just add something quickly? I mean, I think that it's pretty obvious. The direction in which all this goes is going to arise largely from the approach of the main responding parties, namely state and territory governments. And I think there's a sort of a view among some lawyers that that some state governments in particular will, at the moment, do not indicate they're going to agree to this modification of determined rights, even though some lawyers' view is that they ought to, because some of the legal decisions have taken us in that direction and so on. But therefore, the question of whether archaeological findings about what was happening quite some time ago is going to be persuasive for respondent parties is going to depend on, probably, as always in native title cases, as much on contesting interests as a sort of a intellectual appreciation of law and custom. And I think one legal view also is that the placing of constraints against commercial use, as the wording has been in determinations by and large with so many claims where the rights are for domestic purposes and not commercial purposes, that arises from government's desire or need, as they see it, to put a constraint on the usage, the commercial usage arising out of natal title compared to the other interests, the other competing interests, which are, of course, around in every claim. So I just wanted to say, I think, arising out of what Nick said, I think in native title, the difficulty or ease with which classical law and custom is allowed to inform the law and custom of contemporary claimants, despite huge change over 100, 200 years and whatever. We have a situation where that varies a lot, and sometimes respondent parties will allow for a sort of a recuperation, obviously, you know, a cultural recuperation through claimants studying documents and relearning elements of law and custom from classical writings, archives and so on. This happening, I think, a lot in New South Wales, you know, use of Roth in some of the Queensland cases and so on. So exactly where all this goes, and whether, firstly, whether it's going to be resolved that it's a matter largely of legal interpretation rather than evidence from experts, that's one question. And the second is whether the respondent parties, governments, are going to fight this fairly hard as to a modification of what, apart from those legal cases, decisions that have been mentioned in fairly traditional communities, apart from there, whether governments are going to point to what Nick said, and that is that, well, it's all very well, Mr. Expert and archaeologist who's talking about what was happening with stone axes all those years ago, but so what? I mean, what's that got to do with what the contemporary nature of traditional connection to country is and what contemporary law and custom is? So I think that's stating what we all know, but I do think that on this particular any purpose use rights issue, it's yet to be sort of argued out.
Could I just have a supplementary there? And that is then, so why is it, on what grounds was the existence of the right separated so clearly from the exercise of the right? Is that applying across the board with all native title rights, or, but it seems to be expressly emphasized in this case of rights for any purpose, but not having exercised them?
Well, I think that's a really good question, and I'm not sure. My reading of the Rumboria decision, the Borroloola one, and I think this arose in the Pilkey decision as well, others may know better than me, was that the respondent parties, and in some cases anthropologists engaged by those parties, sought to make the point that there was no evidence in their research material for the actual exercise of rights for any purpose, with a particular focus likely on sort of commerce. But then the lawyers for the claimants argued very successfully this issue about it's not a matter of whether it's ever been done, it's a matter of whether in law and custom there is any constraint, which leads us back to the, in a cyclical way, of the difficulty of addressing it. I'll just add one other thing. In Rumboria, what was really interesting in Jeff Stead's report, his having been engaged by the NLC for the Borroloola claimants, there we had a very rich, fairly rich written documentation of the exchanges and interactions with Macassans on the part of Yanyuwa and other people. And if I read Jeff's report correctly, it's mainly historical. It's mainly about what happened during that period, although it goes on to talk about people's subsequent, you know, desires and intentions to mobilise certain cultural forms from law and custom in the sale of art and so on. So he does take it more to contemporary settings as well. But I think that the judge in the Rumboria case was quite positive about that case where a depiction of previous relations of trade and exchange was demonstrated. Although legally, the judge definitely did embrace this point, Nick, that you say is arising more, especially I think, in the case of this any purpose right than in claims about connection, and that is that you can somehow isolate the idea of a right being found to exist separate from what people have actually done or do now.
If I could just come back too on that, I mean, I think there's another issue that may be sort of clouding this slightly. So many of the agreements these days are by agreement and not through litigation, right? So where there are consent determinations, then the fact that people have revived an activity or a right which they hadn't practiced for a long time, which in a sense they'd lost, and then because they've read about it or they've found ways to reactivate it, while that might stand up in a consent determination, won't stand up in a court of law, of course, because you can't give yourself rights. If you've lost a right, then the only person who can give you a right is the state or the crown. So that may be part of the answer, that this separation of the right from the activity is a bit misleading for us in an adversarial position, because if you're not doing it and you haven't done it for a long time and that can be demonstrated, then the fact you've is not relevant.
Well, I think it's, yes, but I also think it's particularly misleading for researchers left with the challenge of operationalizing that very distinction, whereas a predominant legal view at the moment is it's a straightforward distinction, or at least in legal terms it ought to be. That's the nub of the conversation that, as Mike was saying, I think particularly in the case of briefs being written in terms of reference, it's so important for anthropologists to not be swept along by the force of a legal proposition like this and try to point out, okay, well, how will I actually do this? And I might just add one other small comment. I think that up till recently, that's been an issue for this question of commerce and commercial use. And I've been in conversation with a couple of lawyers who've sort of said, well, look, if they had trade, trade is commerce, or any kind of sort of exchange is commerce. And I think my response has been, well, I'm a social scientist, and actually technically in social science terms, that's not really true. You know, commerce is defined in all kinds of social science disciplines with a greater degree of technical specificity, which as an anthropologist, social scientist, I can't ignore. I think the lawyers may then say, well, to some extent, the law operates with everyday lay language. And that may be true. I mean, we've seen that in different cases where, you know, the court will say, I'm not too interested in the technical language of anthropology as a discipline in terms of words like tradition or culture or whatever. I'm going to understand this in terms of what I think the makers of the legislation meant and what it means in ordinary everyday English. So that's been an issue around the term and the concept of commerce as well.
Can I have a word there?
Yes.
To follow up on, you know, with that discussion, You know, in the Borroloola case, Basil Sampson took a kind of fairly blunt knife to Jeff Stead's use of my material on the Kimberley-Woonan exchange and trading system, claiming that it didn't show any kind of commercial kind of aspects whatsoever. And I think, you know, when we're examining the everyday uses, as you said, David, of language, as this is what we're trying to do as anthropologists. I think there's a danger in taking our baseline at sovereignty position as the most elementary form of trading was barter. Because I think, you know, say with the Woonan, it's very much about indirect and delayed exchanges. So in fact, what people are creating is you know, it's obviously, as you said, it's not to extract surplus value in the terms of profit. But what we do have is a strong desire to create indebtedness and credit with the people that one's trading with. And that indebtedness is very much valued. And that's got all sorts of social effects and social structuring effects for all the parties engaged in that kind of trading exchange. So I was really interested, you know, when I read last year David Graeber's book on debt, the first 5,000 years. And he shows that, in fact, rather than what he calls the myth of barter as being the originary myth of trade, that in fact it is that indebtedness that still forms the basis even of modern economic systems, as the GFC showed with modern capitalism. We had a complete a virtual collapse of the ideals of that system because of debt and credit. So, you know, in that respect, we look at the everyday uses of words like commerce. We can see that it's not just a matter of a exchange of one thing for another, because some people had that particular item in their country and other people had it in had another type of item in their country, because there's often mediated exchanges. And yeah, it is, I do think it's the creation of social indebtedness that spills over into all the other exchange relations that happen within these particular societies. So yeah, I think if we go back and interrogate those kind of the underlying concepts that are embedded and unexamined within everyday language, then we have a surer footing to do our explorations of what trading and exchange means in the particular social worlds that we're exploring.
Thanks, Tony.
Can I just make a point there? Firstly, okay, I would take your point, but I mean, of course, I mean, you're just repeating a Mosian kind of model of what's going on, and we all endorse that. The question is, does that appear to outsiders and as gift exchange, where the social relationship trumps any kind of economic utilitarian thing in terms of argument and in terms of, but the other thing, of course, there was direct exchange in the Kimberleys. Love describes it, in fact, it's one of the best descriptions ever of people exchanging things in his book on Stone Age Bushmen today, right? So there was a combination of things going on.
Yeah, sure. But at the same time, even in Love's work, it's not a calculation of the value of, like, one type of item had to flow in a certain direction, obviously, and different types of items had to flow in other directions. And you know, you would end the relationship, obviously, if you cancelled it out with a calculation that this replaces that.
Yeah.
Yeah. So I still do think there's indirectness and delays were really crucial to the system.
Oh, here. No, I mean, I'm not saying most should be replaced or anything. I'm just saying it opens up dangerous ground, or appears to, in this kind of adversarial environment.
It's dangerous in the sense you're saying that the respondents might object that it's not truly trade.
Yes, that it's not. It's all about the social relations and not about the economic, right? And that's what we're trying to show, that there's a document that there was an economic ability to use the resources to utilitarian purposes, right? And it might make it look as if it's not utilitarian. I mean, we're in agreement with the point you're making about indebtedness and all that. Yeah.
Okay.
Yeah, sorry.
You still want to make a follow-up remark?
The only point I would conclude on is that the respondents can only make that argument if they are allowed to present economy as something that's totally different, separate from culture or sociality. So that's the basic division that allows them to mount that argument. But as anthropologists, I think we can reduce that antinomy between those two. Yeah.
It's quite difficult, I think, because I mean, if you go back to the Gove case, I mean, one of the problems there was that Blackburn saw the relationship with the land as entirely spiritual, and in the contemporary climate, everything is spiritual and celestialized and the rest of it. And the fact that people actually had to get a meal out of the ground was completely lost, you know, and that it had an economic value as well. And I think, you know, those muddles, I don't think the court is free from muddles about culture and religion and things in an Aboriginal context.
Yeah. Can I say something here, Julie?
Yes. Can I just say there's starting to be a lineup and we're due to cut out.
Okay.
So John quickly, then Kim, and Tony Jeffries, were you interested too? No. Okay.
I just wanted to make a very specific and but at the same time a general point, and it can be short and sharp. Nick, your guide to the literature is entirely focused on like the stuff that we would regard as pre-sovereignty, but a lot of the conversation that we've had since through everybody is really coming around to the idea that you really need to get a good conceptual hold on this. You really need to start embracing literature that is post-sovereignty. And I would have thought that the most valuable list of stuff that you could get in that regard would be in terms of the way in which, say, Aboriginal people use money, have negotiated with companies who are commercial, unarguably commercial operations, and how they've done that within clearly specified traditional contexts. I'm thinking of places like Arnhem Land or wherever. That whole thing about the basic thing about the right to be asked about, well, that is something that is a kind of basic thing about coming to use your country. And that you can indulge, as long as you are asked and you've gone through the appropriate negotiation, you can then enter into those arrangements with a mining company, for example. I was really struck by that in a case many decades ago, actually, in Alice Springs, where an old fella got really upset about a company sand mining on the country. But he wasn't upset about sand going out. He was upset about not being asked about the sand going out and doing a proper deal about it. So that kind of articulation, I would have thought any evidence along those lines in the literature would be particularly useful in this context.
Thanks, John. And final comment from Kim.
And I think it actually kind of follows on, because I was that point that Nick you're making about how people might argue that Aboriginal trade isn't utilitarian. I mean, I'm just thinking about the almost instant way in which Aboriginal people started trading with white people. I'm thinking about Uldia, for example, where people just out of the desert started trading objects and various things. I was just reading Roth today about, late 1800s around Rockhampton, about people going into town and trading objects and other things. And so I was just wondering if anybody has encountered issues, like has it been challenged, those kinds of trades, as not being traditional or by lawyers? Because it seems to me to kind of, it's like that is the first step into the kind of things that John was just talking about, of just at a different kind of scale.
We have time for a brief response.
Just quickly, of course, if some of the data, so to speak, is going to become negotiations with commercial users of the country along the lines that John was talking about, well, the obvious issue is going to be what's that got to do with traditional law and custom? And I'm putting that bluntly, and we've got plenty of answers for that, and we're going to have plenty of answers, particularly in Northeast Arnhem Land or something. But it is an issue in Southwest Queensland or Western New South Wales or Southwest Australia or wherever. People, of course, will be functioning in those kinds of economic negotiations on the basis of their embrace of issues from the wider society that don't derive from traditional law and custom. And so we're likely to have a mix. So I'm just saying that I think there'll be some contesting of an anthropological analysis which says that the account of the group we're talking about here negotiating with such and such a mining company over doing a deal on use of country indicates something in traditional law and custom about that group's own rights to use the country in a certain way. It may well be that that's an argument that can be made, but it's not going to be without contestation.
Would hardly expect it to be otherwise, would you?
Hardly what, sorry?
You wouldn't expect it to be otherwise.
No, of course. No, but you could, but this issue of which native title is shot through with this issue, what material do we, when we encounter in fieldwork, we encounter material in the lives of the people we're working with, which cannot and ought not be sheeted home to the idea of a continuity of traditional law and custom. I mean, to do otherwise is to ignore what anthropology has been saying for some decades, that of course, the descendants of colonised peoples are changing and embracing all kinds of elements from the wider colonising society and mixing that and so on. I mean, I don't want to put a simple argument here against the continuity of law and custom, but I do think there's some trickiness when we focus on commercial negotiations with big industrial parties and how exactly we frame that as part of law and custom.